Stenner against Teignbridge District Council.
Lords,
yes, Mr.
I appear with Rupert Cohen of Counsel for the Appellant. Learned friend Mr. John Ward appears for the Respondent.
Yes.
I'm going to deal with ground one of the appeal on behalf of the Appellant, and learned friend Mr. Cohen's going to deal perhaps more briefly with ground two, or considerably more briefly with ground two.
Yes.
On ground one, my submissions are divided, hopefully, into the following headings. Firstly, I'm going to look quickly at the tests that the courts below, tribunals below applied. That's in the light of certain submissions made in my learned friend's case. Secondly, I'll examine the case law up to and including and after Batchelor and Marlowe. That's going to be a quick or relatively quick canter through the case law, because we say, as we said in a written case, that actually the test adopted in Batchelor and Marlowe, which was first set out in London and Blenheim, doesn't actually reflect previous case law. Thirdly, I'm going to look at the criticisms which have been levelled at the test in Batchelor and Marlowe, not least by the House of Lords and the Law Commission. Fourthly, I will look very briefly at the Commonwealth authorities, and we thought it might be worthwhile having a look at what the courts have said in Australia, Canada and New Zealand. And five, I will set out why we say the current test for the Ouster Principle as articulated in Batchelor and Marlowe is the wrong test. And six, I will look very briefly at whether it makes a difference in this or any context as to whether the right that we claim is acquired by prescription as opposed by direct or indirect grant. And seventhly, I'll apply the test to the facts here or make submissions on that. And eighthly, I will deal briefly with one point made by my learned friend in his written case.
Yes.
Before I do, we are dealing here with what Lord Briggs has said in the Regency Villas case is the fourth, or one of the ragbag of rules in the fourth condition of pressure, that is, whether the right is capable of forming the subject matter of a grant. Now, we of course accept that there has to be a dividing line between a right which is an easement on the one hand and a right which, or an interest in land, an estate in land, a leasehold or freehold on the other, and indeed on the other side between that and a mere licence to occupy land. Section 1 of the Law of Property Act 1925 recognises that there are estates in land, subsection 1, and there are interests in land, subsection 2. And the issue here is how one draws the line, or where one draws the line, I suppose. And the issue is, to quote Lord Newburger in Moncrieff and Jemison, the degree of ouster required to disqualify a right from constituting an easement. If you want that quoted in page 769 of the authorities bundle at paragraph 143. That I refer to as the Ouster Principle. So that's a different term, because we accept, I mean, the Law Commission said, oh, the Ouster Principle should be abolished. With respect, they probably misspoke there, because there has to be some sort of dividing line, whether one calls it the Ouster Principle or not. But the Ouster Principle is that the degree of ouster required to disqualify a right from constituting an easement. And Lord Briggs in Regency Villas said that the right is not so extensive or invasive as to oust the servient owner from the enjoyment or control of the servient tenement. And that's at page 877 of the bundle, if you want that quote. Before I start into the 8 points, as a preliminary point, as I've said, we accept there has to be a dividing line, and this court has to decide where it is. Secondly, this is judge-made law. The origin of the Ouster Principle is said to be the Scottish House of Lords case of Dyson Hay, which I'll turn to very shortly, and the current iteration of the test as applied by the tribunals below is set out in a Court of Appeal case, Batchelor and Marlowe. There are no relevant statutory provisions which would bind or trammel you. Thirdly, in our submission, there's no authority which binds this court as to where one draws the line. And therefore, there's nothing to stop this court, if it wishes, adopting the views expressed by Lord Scott and Newburger in Moncrieff and Jemison, and to the extent that it is binding authority, overruling Batchelor and Marlowe or disapproving it. And fourthly, the law is currently regarded as unclear, the present position. And with respect, my learned friend appears to agree. If you look at paragraph 17 of his written case, he says, page 53, on any analysis, the scope of the Ouster Principle is undefined. There are conflicting authorities and it has been extensively criticised. And we, in our written case, cite the passage from Gale on easements, which is at 1290 of the bundle, if you want to look at it, which says the law is not clear as to the precise boundary between a right which can be an easement and a right which is too invasive of the rights of the owner of the land to be an easement. And indeed, Lord Briggs said as much in the Regency Villas case, where he said, paragraph 61, which again is at 878 of your bundle, the precise extent of the Ouster Principle is a matter of some controversy. This court may feel that this is a case in which that controversy has to be settled one way or the other. So the first point I'm going to make is to look at the test that actually was applied in the tribunals below. Now, I do this because right at the end I'm going to deal with a point made by my learned friend in his written case as to what the test actually is. But the test, it's quite clear what the test that was applied by the lower tribunals is. If you look at page 80 of the bundle, it's paragraph 65 of the judgment of Mr. Justice Edward Johnson. And he says, in summary, therefore, the question which the first-tier tribunal had to ask itself in this case was the question formulated by Judge Paul Baker in London and Blenheim Estates, which was adopted and applied Batchelor Morrow. For ease of reference, I repeat Judge Paul Baker's formulation. He sets out there the essential question is one of degree. If the right granted in relation to the area over which it is to be exercisable is such that it would leave the servient owner without any reasonable use of his land, whether for parking or anything else, it could not be an easement, though it might be some larger or different ground. That is what has been applied.
Can you just give me the paragraph again? Sorry.
I'm sorry, it's paragraph 65.
65,
of the upper tribunal's judgment. I'm sorry. And that was the test is again made clear in paragraphs 75 and 76 at page 82 of the bundle. So the test applied by both the first-tier tribunal and the upper tribunal is that set out in that quote from the London and Blenheim case, which was adopted, we say, in Batchelor and Marlowe. That is, whether the supposed right would leave the servient owner without any reasonable use. It's just this, if one looks at paragraph 90 of the upper tribunal's judgment, which is at page 84, it might be said, if you look at that last sentence, in the present case, it seems to me that the first-tier tribunal was quite entitled to view the disputed easement as a claim to the whole beneficial user of the triangle during the relevant period, in much the same way as Mr. Justice Upjohn viewed the rights claimed in Copeland Green have. Now, it might be said, I don't think it is, but just to knock that in the head, it might be said that that's the test which was applying, whether it left the Teignbridge District Council without... removed the whole beneficial user. But with respect, that's not the test which both either the first-tier tribunal or the upper tribunal applied. And it comes back to the point I'm just about to make as to what was said in the authorities prior to Batchelor and Marlowe about the relevant test. But the test they applied is that set out at paragraph 65.
And in the first-tier tribunal, which are the relevant paragraphs?
If you look at paragraphs 55, page 120 of the bundle, my lord. At paragraph 55 and 56, Judge Green describes the London and Blenheim case and says that sets out the same test and says this was endorsed by the Court of Appeal in Batchelor and Marlowe. And then if you go over the page 121 and look at paragraphs 59 to 60, My Lords, the reason that I emphasise that or make this point is due to certain submissions made in my learned friend's written case, where he appears to say that either there is or ought to be an additional limb to the test, that is, whether it renders the ownership of the servient land illusory. I'll come to deal with that right at the end, but the point I make here is that is not part of the test that was applied in this case, and one can go back to what Mr. Justice Edwin Johnson said when he granted the leapfrog certificate. It's clearly that it's that whether it's a reasonable use, the deprivation of any reasonable use is the test. With that, that's point one. Point two is looking at the case law. Now, my lords and my lady, of necessity, given timings, this will be a fairly brief canter through the authorities. For the first time, I'm going to try and use the soft copy PDF as opposed to the hard copy. But if, no doubt, if I'm going to quickly, or the tribunal wants some further information on the background, then no doubt I'll be asked specifically, and we'll be very happy to do that. If you want a brief history of the origin of the law of easements, if you look at the case of Re Ellenborough Park at 924 to 925 of your bundle, you will see in the judgment of Lord Evershed that there is a history there setting out the origins. We haven't bothered to do that, largely because not only the Law Commission but our side and the learned friend accept that the origin of the Ouster Principle is the Scottish House of Lords case of Dyson Hay, to which I'm about to turn. My lords, that starts at page 529 of the bundle. And I suppose the first thing to look at is the side note at the top, which says there can be no prescriptive right in the nature of a servitude or easement so large as to preclude the ordinary uses of property by the owner of the lands affected. That has been used as the ratio of the case, although it was described by Lord Scott in Moncrieff and Jemison as unhelpful, and in our submission doesn't really reflect what was said in the case. If you look at the right that was being sought in that case, it appears, if you go to 533 in the judgment of the Lord Chancellor.
Sorry, can you give that number again?
533, milady. It's the top, the first paragraph. What is insisted upon, therefore, is of this extensive nature, that the pursuer claims as an inhabitant, but in fact on behalf of the Queen's subject, all the Queen's subjects, the right to go at all times upon the closed soil of a portion of the appellant's property near the mansion house for the purpose of recreation, just as think proper. Now that I conceive as a claim so large as to be entirely inconsistent with the right of property, for no man can be considered to have a right of property worth holding in a soil over which the whole world has the privilege to walk and disport itself at pleasure. And there's a further comment about 3/4 of the way down, which I would highlight. It's the words "in short." It's about 12 lines up from the bottom. In short, I cannot myself imagine the use to which this property could be turned if that great power claimed on the public behalf was to be held valid. Lord Scott in Moncrieff and Jemison categorises this as a claim for a public right, but it appears to have been a claim actually for a private right on behalf of the public, which I'm not sure how that works. But if you look at over the page at 534, again, the first paragraph it starts. When you look at the number of persons, some hundreds of thousands perhaps, for whom this right is claimed with their families and dependents, it is in effect a demand on the part of the public at large to resort to this spot for recreation, exercise, strolling and lying down particularly, for when they walk or get tired they claim a right of reposing themselves on the surface of the soil. And again at the bottom of the page, 5 lines up, your lordships must, however, at once perceive that if such a universal privilege were conceded to restrain or regulate the mode and limits of enjoyment would be altogether impractical. If I continue, now, my lords, before I enter upon the cases, there's one thing to which I must particularly guard myself and must anxiously beg the House may not be understood as expressing any adverse opinion. I mean that right to which the right in question in this case has been improperly assimilated, the right of village greens and village playgrounds, the enjoyment of which has been dedicated to the public. And if you go then to the bottom of that paragraph, just past the middle of the page, he says, concludes, those rights will remain untouched and are unassailable, be the fate of this case what it may. So, in other words, he's expressly saying this case is not about town or village greens. At the top of the next page, page 536, in your bundle, he says, my lord, there's been a considerable argument about the questions whether it's possible for Mr. Dice to represent the persons on behalf of whom he claims, and whether, looking at the law of Scotland, which in this respect differs from the law of England, he can be considered as having necessary dominant tenement which will apply to the serving tenant and support the right. I think your lordships need not go into these points, which, however, it would be necessary to consider. So I'm just pointing to highlight that because it highlights the fact that the law of Scotland was said by the House of Lords here to be different from the law of England. There's one particular, I'm not sure it matters, but if you go 536 and 537, the paragraph there, at the top of 537, if you look at that, it might appear to say, or might appear to be saying that the right of recreation is not really a right which is recognised as an easement at all. If you go to the 537, the bottom of that first paragraph, where he says, but the argument to which I'm referring can have no application in this case, because I fancy no one supposes that recreation, taking the air and strolling, are to be regarded as any particular novelties, or that if you're tired in a meadow and lie down to repose yourself for the refreshment, thence arising can reasonably be described as an invention. The case of Home and Young, therefore, in which these arguments were used, has nothing to do with the present. Now, it might be, on one first blush there, he'd be saying, well, we don't recognise the right to recreate as capable of being an easement at all. Again,
what do you say is the ratio of this case?
Well, it's difficult to find. The ratio of the case is that the right claimed, which was a right on behalf of members of the public to recreate on a defined a patch of someone's land, wasn't an easement under the law of Scotland. That's about it. And the point is, again, so I'm cutting to the chase. If you look at page 539, at the first paragraph, he describes certain comments made by Lord Eldon. But if you then go to the last sentence of that, he says this, it is quite clear, therefore, that the impression on the mind of Lord Eldon was that no such right could be claimed as would be inconsistent with the rights of property. My lords, I think, therefore, that by the law of Scotland, that is a right which cannot be maintained. I think more of it's a right which ought not to be maintained. The appellant has endeavoured to invoke the aid of the law of England in his favour, but I apprehend the law of England is more decidedly against than that of Scotland. Now, I would emphasise the comment there by Lord Eldon. It's quite clear, therefore, that the impression on the mind of Lord Eldon was that no such right could be claimed as would be inconsistent with the rights of property. And I'd match that, if you go back to 533, with the passage I've already read at the top there, at the bottom of the first paragraph, now that I conceive as a claim so large as to be entirely inconsistent with the rights of property. And then one goes back at page 529 to the side note, which has been influential. It says there can be no prescriptive right in the nature of a servitude or easement so large as to preclude the ordinary uses of property by the owner of the lands affected. And we make a number of...
So you say that's different?
It is. It's not the same. And hence Lord Scott described it as unhelpful in Moncrieff and Jemison. But that's the one that's cited. If you look at a number of cases, you'll see that's the ratio as cited as to what Dice and Hay means.
I mean, Lord Eldon's, or the point made about Lord Eldon, saying that no such right could be claimed as would be inconsistent with the rights of property. I mean, seems a little bit curious in relation to easements generally, because, I mean, if you have an easement, you can go on someone's property and they can't stop you. So to that extent, an easement is inconsistent with the rights of property.
It is. Well, it's a property right itself. But insofar as that means, we would say it probably means, or was intended to mean, the rights of ownership, or the rights of, we would say it's more consistent with the legal possession. It's inconsistent with possession of property, or legal possession of property. In any event, what it doesn't mean is what the side note says, that it's inconsistent with the ordinary uses of property, and that's maybe where the use of the word use has derived. But this is a Scottish case. Again, nothing wrong with Scottish cases, but it was clear that the law of Scotland was regarded as different from the law of England. The side note, as I've said, we say doesn't really reflect what was said in the judgment. Insofar as the case decides that one cannot have an easement of recreation in favour of a dominant tenant over a defined servient tenement, then it doesn't any longer represent the law of England, re Ellenborough Park and Regency Villas. And 4, insofar as the case holds that there cannot be a private right as opposed to a town or village green right, or right of common or statutory right in favour of the general public over private property, then it's uncontroversial. My lords, I know my lords, Lord Sales and Lord Burroughs will recall town and village green cases, which is a separate public right of ancient origin, now derived from statute. Whatever it is, this case is, we would say, an insubstantial foundation for what is currently the Ouster Principle. I'm going to turn now to Riley and Booth and deal with that very briefly. It starts at 837 of your bundle. And that was the conveyance of a passageway, the exclusive use of a gateway, which is held to be a passageway. And if you go to page 851, in the judgment of Lord Justice Lopez, he sets out what the conveyance was, the year he explained how it's conveyance to Teignbridge, which we are called to construe. And then 7 or 8 lines down, he quotes it together with the exclusive use of the said gateway into Oxford Street. So that was what the conveyance was, exclusive use of a gateway underneath some buildings into a rear of Oxford Street. And the question was whether that was an easement or a conveyance. And the Court of Appeal said, in my opinion, Mr. Warman's contention is right. I think ownership past the exclusive use of the said gateway was given. The exclusive or unrestricted use of a piece of land, I take it, a reasonable question passes the property or ownership in that land, and there's no easement known to law which gives exclusive and unrestricted use of a piece of land. It's not even an easement in such a case, it's property in the past. So the Court of Appeal were able to construe what was being granted there, not as an easement right, but rather as a conveyance of the freehold.
Why did it matter in that case?
I think if you look at the it was...
Maybe it doesn't matter.
I don't think it does.
Wasn't the question whether the gateway was part of what was actually sold?
Yes, well, that was the difference. It was it an easement? Did you have a right to use it, or
Yeah, but it mattered, presumably, because you needed to know who owned it.
Yes.
And presumably this exclusive use didn't seem to have any temporal restrictions or dimensions to it. It was just the exclusive use.
That's right.
And that's why the unrestricted exclusive use without any temporal restrictions amounted to the sale.
Yes, it was construed as a conveyance of the freehold and not as the grant of an easement.
Yep.
And it's the exclusive use. So it draws a line there. The rights that were granted, we construe the rights that you have got by reason of this conveyance over this land as in effect of the grant of a freehold or the conveyance of the freehold rather.
My understanding of this case was that they were really just trying to decide, as it were, what had been sold, because there were a couple of yards and then this passageway from the yard to Oxford Street.
Yes.
So the question is, did you sell that or didn't you? And the answer is yes, you did, because you gave exclusive use without any restriction.
Yes, my lord, I'm not going to dissent from that. No. But yeah, the point is it draws a line. There's the Court of Appeal drawing a line as to what it was said it was an easement, it's not. I'm going to deal now with two cases to do with storage rights. It's slightly out of order from our...
I mean, just to go back to...
Yes, no, my lord.
I mean, if you just said if the conveyance had been together with exclusive use for 5 years, so convey the yard with exclusive use of the gateway for 5 years, would it have been a different result?
It can't have been a freehold because that's eternal. It might have been a lease or otherwise, depending on what was granted. Or the court, I mean, it might have been difficult act of construction as to what right was granted. But for 5 years, it can't have been a freehold. It might have been a lease. It might have been construed as a lease. I mean,
but your point is it couldn't be an easement.
That's right.
That's right.
Yeah. Just on my latest question, I think page 839
I'm grateful.
explains why the parties were arguing about the issue in the case. It's because the person who had the right of use of the passageway had done various things, and it was said, well, these things are not things that you're entitled to do in exercise of an easement to use the passageway. I mean, he had treated it as his own property, and so the question was, is it his own property? And the answer was, yes, it was.
It says he fixed unseemly glass.
I know. Shocking, I know. But,
Yes.
I think that's...
It'd be quite nice to have gas lamps in Oxford Street these days, but...
Yeah. Aesthetic standards existed even then. And people argued about it.
I'm a property lawyer, I don't deal with aesthetics.
All right, thank you.
My lord and my lady, I'm going to deal with the Southern Nigeria case and the Wright and McAdam case. Now, those are two, they fall in a chronological order from the cases I'm going to deal with. Those were two cases where first the Privy Council and then the Court of Appeal were prepared to recognise storage rights as an easement, a right to store coopers, stores, casks, trade goods and produce in the former, and a right to store coal in a coal shed in the latter. And Wright and McAdam was famously not cited to Mr Justice Upjohn in Copeland and Greenhalgh. The Southern Nigeria case starts at 396 of your bundle. That was a case where land had been granted on the seafront in Lagos, and it had been land that was then built up by the owners and occupied. And the question was under what guise they occupied that land, because it was I think it's a compensation case because the land had been compulsorily acquired for a roadway and cleared. And the question was, what were the rights of the landowners?
And the page reference for Southern Nigeria?
Sorry, it's page 396 it starts.
Yes, thank you.
And it was found it couldn't be accretion. If it was accretion, it would have been a natural accretion. It would have been their land, but it wasn't. It had been deliberately built up. But the factual matrix or factual background is at 403. And if you look at the middle paragraph there, the respondent is further admitted that stores, sheds and other works at different dates upon the land adjoining the waterside, particular upon not inconsiderable portions of the soil of the land in question case, namely action foreshore, i.e. land between the high and low water mark stored in spring tides. The respondent and the predecessors used the foreshore and land for storage in the purpose of their business, and the wharf and piers already mentioned were also used by them in connection with their trade. While upon the one hand there seems little doubt that for half a century continuous use and possession were had, the kind that you just described. And the respondents accepted that there was what they call exclusive occupation, if you go to 401 of that. But the Crown argue, if you go to page 400, the Crown, this is the argument for the Crown, 400, the Attorney General appeals only from so much of the judgment of the full court as declares that the respondents are entitled to an easement to place coopers, stores, casks and trade goods upon the reclaimed land. The respondents were in exclusive possession of the surveyed land and could not therefore acquire an easement over it by prescription. Further, the easement is too wide, it's not confined to the respondent's own goods and might extend to the occupation of the whole surveyed land. There's no English authority to support an easement of this character. That was the argument half the Crown. The Privy Council disagreed as a matter of principle. If you go to page 414, and can I ask the court to read the first two paragraphs on that page? That is the one that starts the judgment of the full court as affirmed, and the paragraph that starts their lordships see no reason.
Yes.
My Lord, I'm grateful. As you will see in that second paragraph, the Privy Council were quite happy to accept that that there could be an easement to store goods. However, if you then look at just the paragraph beneath that, that's obiter, because they say, but in their lordships, but the second contention of the Crown is correct. And the second contention of the Crown was that in any view, the use to which the land was put by the responsibility title could not be the foundation of an easement, as it was not a right assumed to be taken or asserted over the land of another. So the Privy Council's acceptance that one could technically have an easement to store, such as was described, is an obiter remark. Wright and McAdam, however, is a Court of Appeal case where it's part of the ratio. The facts it starts at 108, but if you go to it's 1087 of your bundle, my lords and ladies. And effectively it concerned the use by a tenant of a coal shed. One isn't given much detail as to the nature of the coal shed or the nature of the use of it, say that it was to store coal. But the issue was whether that had become an easement or become a right attached to a further tenancy by reason of Section 62 of the Law of Property Act 1925. And just a number of passages from Lord Justice Jenkins. If you go to 1093, it's just below the halfway down the page, the paragraph. The next proposition deducible from the cases is the one laid down in Burroughs and Lang, which has to be referred to in some of them, as I've said. It is that the right in question must be a right known to the law. The point is, one of the issues here was the nature of a right which could pass, which could pass from being precarious to being a legal right by reason of Section 62, and the law is that it has to be such as would be recognised as an easement in any event. And he says that at 1094, the purpose of Section 68, which is 8 lines down from the top of the page, for the purpose of Section 62, it's only necessary the right should be one capable of being granted at law, or in other words, a right known to the law. to right of that description, it matters not, as an international tea stores case shows that it's been in fact joined by permission only. Reason for that is clear, or on the assumption the right is included in forcible parcels of the conveyance by virtue of 62, the grant under the conveyance supplies what one may call the defective title and substitute a new title based on the grant. So they held that in order to pass under Section 62, the right has to be recognisable as an easement otherwise. And then at the next page, 109.5, he says this, again, halfway down the page, the right was, I understand, the right to use the coal shed in question for the purpose of storing such coal as might be required for the domestic purpose of the flat. In my judgment, that is a right or easement which the law will clearly recognise, and it's a right or easement of a kind which could readily be included in a lease or conveyance by the insertion of appropriate words in the margin. This is therefore not a case which the title to a right unknown to the law is claimed by virtue of Section 62. So again, the Court of Appeal were quite happy to recognise the right in this case, which is a right to store coal in a coal shed, as an easement.
How do you distinguish between an irrevocable licence and an easement?
There's no such thing as an irrevocable licence.
Well, there appeared to be a suggestion in the previous Privy Council case that was sort of at least part of the argument. I couldn't detect whether it made its way into the judgment, but it was certainly part of the argument.
Well, it's difficult to see that because the whole point about a licence is it's a personal contractual right. Now, you can get a licence which is assignable, but normally a licence terminates with, for example, the death of the licensee. But my answer to that is, and it's a point which Lord Neuberger raised in his judgment in his speech in Moncrieff and Jemison, is, well, how does one distinguish between what's the import of licences, and distinguish between an easement on the one hand and a licence on the other, or a transfer of the freehold?
No, I mean, just to take the coal shed, if I said, for so long as you own the property, you can store coal in the coal shed. I mean,
that can't be an easement, because it's not an easement is an interest in land under Section 1(2) of the Law of Property Act, and it passes automatically with the freehold.
Right.
Or with the leasehold interest. So that's the point. That's the difference between a licence on the one hand and an easement on the other. A licence is a personal contractual right, which can be assignable and can be for a lengthy period, but it's not a property right, and thus doesn't pass automatically on conveyance of the property. If I have an easement, if I own property A and I have an easement over property B, and I convey property A, that automatically, provided the registration provisions are complied with, that the easement automatically transfers with the vehicle.
And so if you're looking at what species of right such a right might be, the critical test is it intended to pass with the land?
That's right. I mean, there's even some authority I've dug up on this. If faced with a written agreement, right, there's a written agreement, the court has to construe it and work out what rights and obligations it covers, and secondly, then categorise it if that's an issue. So if you get a written agreement I'm allowing you to walk over my land, you've got to ask, the court has to construe it and work out what rights are granted, and then has to categorise it. Well, given how I have construed this agreement, the rights I have construed the rights granted. One, is it a freehold transfer, as in the Riley case? Is it a lease? Is it the grant of an easement, a freehold right, or is it a mere licence? But that can occasionally be a difficult task. For example, there's reams of authority on the difference between a lease and a licence. But the task is the same. You look at the written agreement, construe it, and work out what rights and obligations are granted or transferred, and then categorise it. I'm thinking of a passage, there's a Court of Appeal judgment of Lord Justice Lewison called La Leyva, wherein he cites a previous Supreme Court case called Secret Hotels 2. It just basically says, it may be a statement of the obvious, but it means courts are well used to dealing with categorizations. You construe the agreement, then in the light of your construction of the agreement, you categorize it. Is it a lease or license? Is it a consumer agreement? Is it a mortgage or charge or something? So it's an exercise the courts are well used to carrying out. And that would include, look at this document. Is it the conveyance of a freehold? Is it the grant of a lease? Is it an easement or is it a license?
Just in relation to what my lord was putting to you about is the test, is it intended to run with the land? I see that at page 1095 in the paragraph you were referring to,
yes,
importance is attached to the fact that it's not a case in which it can be said to have been in the contemplation of the parties that the enjoyment of the right should be purely temporary, no limit set as to time. So it's unlimited as to time, which is an indication that it's supposed to run with the land.
That may be, it's a slightly different case there because that was a Section 62 case, and under Section 62 you can have a permissive right can become a legal right.
Right, but it still has to be in the character.
Oh, yes, yes. You have to look at the permission that was granted, and if it's only a temporary permission, look, you can use this coal shed for 2 years, then it won't pass under Section 62 as become a legal right.
So it could be temporary for 2 years.
Yes.
Could be for so long as you own the land.
Yes.
It's indefinite but personal.
Yes.
And then it could be intended to attach to the land,
yes,
be a property right.
Yes. I mean,
and you say those are the three types of analysis.
Or it could be, as in Riley, the grant of a freehold. You have exclusive use of this patch of land. Now, the Court of Appeal in the Riley case construed that as a conveyance, not just merely an easement, a right to use my land, but it now becomes your land. I think that's the point.
Which is much more likely if you're dealing with something which was a conveyance of a contiguous piece of land, much less likely if you just grant the right to store coal in a shed. It's quite a leap to say that's a conveyance of the coal shed.
It is, but in the context of it, I mean, it was a permissive right. It was, I think they said it was the lady had a tenancy and was allowed during the tenancy to use the coal shed. And then there was a grant of a new tenancy, and it was said that, and she continued to use the coal shed, and it was said that by reason of Section 62, the previous precarious right had crystallised into a legal right. I think that's the context of, because I think it was the lady's daughter. She was asked to pay for the right, and the lady's daughter said, no, we've got a right under Section 62 now, because we were using it when you granted us a new tenancy. The point for present purposes is that the Court of Appeal were prepared to hold as a ratio, part of the ratio of the case, that a right to store coal in a coal shed could be an easement. And there is, if you look at the Holt case and the Wright McAdam case, there's no great discussion about the Ouster Principle, and the factual detail is lacking in both cases. One doesn't know the size of the coal shed. And as Lord Scott points out, it may be a difference. If I grant you the right to use my coal shed and there's no door in it, it can be an easement. But if I grant you the right to use my coal shed and there's a locked door and you have the only key, and that's the arrangement, well, then you might say, well, that's not an easement. That might be more an exclusive use, as in the Riley case. But that you might have to construe that. But the point is this, that these are both cases where first the Privy Council and then the Court of Appeal were prepared to recognise easements of storage. And
I mean, the reason for my question was if you go back to Holt and just look at the head note appears to suggest that the Privy Council recognised a licence. And that's what was confusing me.
I'm sorry, which page?
Sorry, page 397, head note. There was to be presumed in the respondent's favour an irrevocable licence from the Crown to erect buildings and store goods.
I think
That's what led to my question to you.
I think the point there is that this was the context is it's a compulsory purchase case, and the issue was what license they had, and I think the irrevocable license has nothing to do with, we would submit, the easement, or rather the passages I rely upon don't rely upon there being an irrevocable license, and nothing that is said about that can affect what we the passages, the obiter bit. It was a slightly complicated factual scenario, but as you see, what was again, it was to do with compulsory purchase.
But you'd say an irrevocable licence is a conceptual impossibility.
Yes, I mean, I've seen recently a licence for 99 years granted to a company, for example, it was a right to deposit waste. So you can't have licences that by deed and license a very long period, but a license, for example, had, and that licence was assignable, as contractual rights are.
Yeah, but just as you can't have an irrevocable contract, in the sense that...
No, but suppose the company, for example, to whom the irrevocable licence had been granted was struck off, failed to file its accounts and was struck off, then the licence would terminate. That wouldn't be the case. Now, what would terminate subject to any complicated rules as to whether the right of the licence, the licence right vested in the Crown as bona vacantia. But as a matter of
one needs to be slightly careful about the terminology of irrevocability here, because as between two persons who are parties to a contract, they may specify that as between us it's irrevocable. And this, I think that's the sense in which it's being used here, because it's the licence between the Crown and companies. And for as long as those two persons, which can last over a very long period of time, it seems to have been intended that that should be irrevocable. So I think your point is that there's a fundamental difference between personal rights and property rights.
I'm sorry if I haven't made that clear.
No.
That's
it's just to get the terminology so that it doesn't confuse us.
That's right. Well, I say an easement is an interest in land under Section 1(2) of the North Property Act, whereas a licence is not. I've dealt with the right macadam. I now need to deal with Copeland and Greenhalgh, which is at page 508 of the bundle. And that was a case where a prescriptive easement was claimed to store cars to use a strip of land by the side of a private roadway for depositing vehicles and for other purposes connected with a wheelwrights business. And the factual findings are at 511. The paragraph begins, the practice established, I find, is this. So that's what the facts were. There had been use during business hours of this strip of land by it was a dirt track, but it was a highway strip of verge for storage of vehicles and wheels for the purpose of the wheelwrights business. Dyson Hay and the Southern Nigeria case were cited, but Wright and macadam were not. And the submissions made on behalf of the landowner start at the bottom of 511. The right claimed here is quite unreasonable, amounts to an ouster of the plaintiff from the beneficial enjoyment of her land. Dyson Hay establishes that the right is a wide extent as to interfere with the ordinary proprietary rights of the surveyed owner, cannot be prescribed for, and that an easement can be lawfully acquired only if it's capable of judicial definition. So that was the submission made by the landowner, and that was one upheld. If you go to 515 in the judgment of Mr. Justice Upjohn, he cites from, and he's citing there from the Holt case, and there's a long quotation in the first paragraph that starts on that page. And then the comment of Mr. Justice Upjohn at the end of that quote, or in the middle of it, he says this, and it's about halfway down the page. I read that sentence as meaning this: there is no reason why there should not be a valid easement for the purposes of storing on the land coopers, stores, casks, trade, goods and produce. So that's what Mr. Justice Upjohn concludes from having looked at the Holt case. And then he goes on to cite Dyson Hay.
And you say that's wrong, because you say there can be an easement of storage.
No, well, he says there's no reason why there should not be.
He's saying
Sorry.
That's right. So
I read it wrong.
He's got that right.
He's accepting it. I'm so sorry.
That's
So sorry.
no, that's not a problem.
I read it.
And if you go to where are we now? And then he continues at 518. That's the passage I want to take you to. And it's the first paragraph which starts on that page. So far, therefore, as that point is concerned, I decide that it does not avail the plaintiff. But I must return to the point of uncertainty. I think the right claim goes wholly outside any normal idea of an easement, that is, the right of an owner or the occupier of a dominant tenement over a serving tenement. This claim, to which no closely related authority has been referred to me, open brackets, Wright McAdam wasn't, close brackets, really amounts to a claim to a joint user of the land, defendant. Practically, the defendant is claiming the whole beneficial user of the strip of land on the southeast side of the track. He can leave as many or as few lorries as he likes, for as long as he likes. He may enter on it by himself, as servants are aged to do repair work thereon. In my judgment, that is not a claim which can be established as an easement. It's virtually a claim to possession of the serving tenement, if necessary to the exclusion of the owner, or at any rate to a joint user, and no authority has been cited to me which would justify the inclusion of a right of this wide and undefined nature in the proper subject matter of an easement. Seems to me that to succeed, this claim must amount to a successful claim of possession by reason of law and adverse possession. I say nothing, of course, as to the creation of such rights by deed or by covenant. I am dealing solely with the right arising by prescription. And that's quite a well-known passage. And
I mean, it's slightly curious, that point at the end, drawing a difference between what could be done to create such rights by deeds or covenant, i.e. by act of the property owner, and contrasting that with a right acquired by prescription.
It is, but he does say, I say nothing about. So yes, it would, by implication, he might seem to be drawing a distinction or a potential distinction in principle between rights acquired by prescription on the one hand and rights.
I see.
By
So he might be saying, and you couldn't do this by deed or by covenant either.
Well, he might be, but he might be saying, well, you might be able to, but he's not saying anything definitive.
Yes.
And in any event,
Right.
there are other authorities further up the judicial food chain which would appear to contradict that. And that's what I need to deal with very briefly.
Yes.
In a moment.
And this is the passage that Lord Scott said, if the facts support his view that this was excluding the owner, then he can understand it, but otherwise
Yes.
he didn't think
That's
that.
right. And my point is this, that if you look at what Mr. Justice Upjohn says, he says, the defendant is claiming the whole beneficial user of the strip of land on the southeast side of the track. He says it's virtually a claim to possession of the serving tenant, less the exclusion of the owner, or at any rate a joint user. And we say that's on a piece with what we say is the proper test, that is legal possession. It's not a test, we say, where one looks at whether the servient owner is deprived of any reasonable use. He's looking, it's virtually a claim to possession of the servient.
What does the whole beneficial user mean?
Well,
I mean, I know you criticise the whole concept of reasonable use or use.
Yep.
I think underlying your submissions is that the question of use is really not ever relevant to property rights as such, or the creation or destruction of property rights. Maybe I put that too high, but you criticise it as a test. But I mean, what does whole beneficial user mean in this context?
I'll make 2 points. Firstly, use is not a defined term. our whole point is that legal possession is a defined term. It might be difficult to write, but use is a sort of amorphous phrase. It depends on its context. But I think what Justice Upjohn was getting at there, and the second point is, it's not reasonable use he's saying the whole beneficial use. I suspect what he's saying, and I would submit what he's saying, is he's saying this is more like a Riley case, where in fact what you're claiming is the entirety of the property.
It's exclusive possession.
That's right. It may be as a synonym for exclusive possession. And that's, if you look at then what he picks, virtually a claim to possession, and the claim must amount to a successful claim of possession.
Could the servient owner walk across the strip? Are there any findings as to could they walk across it when it was being used with lorries?
I don't think they could.
They couldn't.
It's 511, I think, is the. Actually, the most detailed statement of facts is that it says 511.
They could presumably just thread their way between the cars.
They could occasionally, if I imagine. I don't know, but find this a fact. 50 years past, defence prisons have been in the habit of storing on the southeast side of the strip vehicles awaiting repair. I'm reading from 511, and that they have been stored on any part of the southeast side of the strip. Been stored on any part, so it provides adequate means of access to bare bones orchard is left. So there was some access, such adequate means being a width of something like 10 feet. Subject to that was Venice predecessor for the last 50 years using the southeast side of the strip for depositing vehicles awaiting repair. Things there. Nature of vehicles placed in the strip has of course changed. I think there was an orchard behind the verge. This was the verge, it's an L-shaped verge off a dirt track, which was a public highway, and behind that was an orchard. And they've never excluded access to the orchard behind the strip. They had used the entirety of the strip as and when they wanted.
I mean, as I understand it, your criticism of some of the cases is that the expression enjoyment or use are just too vague or uncertain to be workable, and you say possession is much clearer because it has a defined legal concept.
That's right. I mean, the phrase is reasonable use, any reasonable uses, and that is, we criticise that as the Law Commission and indeed Lord Scott particularly. Yeah,
but do you criticise the word reasonable for being uncertain, or do you criticise the concept of use?
Both. I mean, the point of one of our criticisms is, in order to work out, as the judge did here, work out what reasonable use is, you have to come to a value judgment, and you have to look at what uses have been there have been, and then work out whether that's a reasonable, that's a value judgment. I'll deal with that now. If you look at paragraph 90 of, is it paragraph 90? It's
Just before we leave this, sorry, just while we've got this in front of us, 518.
Yes.
I mean, your main proposition, though, is that this is just wrong, isn't it? I mean, you're saying, Mr. Justice, up wrong. I mean, you're trying to put an interpretation that might mesh, but I mean, effectively, these facts and this analysis, you would want to say is incorrect, wouldn't you?
I say two things, yes.
Because he's using the word practically. The defendant is claiming the whole beneficial use of the strip of land. Well, you could say that in our case.
Yes,
exactly.
Yes, I do. I say that. But what I say he might have got it right is it's virtually a claim to possession. Like,
well, he's used the word virtually again. I mean, I don't know why you're not just full frontal saying he didn't cite and didn't have cited to him right to McAdam, and his actual exposition, as applied to the facts of the case, is incorrect.
Well, I don't have to go as far, I suppose, as to say that he got it factually wrong, given the limited detail we know about the facts. But yes, my point is twofold. One, whatever test he applies here, it's not deprivation of reasonable use. It's not the test which was set out subsequently by His Honour Judge Paul Baker QC in the London and Blenheim case, as applied in Batchel and Marlowe. And secondly, insofar as he almost gets to the claim for possession, he's getting towards the right test. But to use the phrase the whole beneficial user, we say is false. It's incorrect. You need to ask, we say properly, on the facts of that case, did the claimed right deprive the servient owner of legal possession of the strip of land? And probably it didn't. So it's probably wrongly decided.
Well, it didn't, because it allowed access. I mean, if it did, then you would fail.
Yes. It allowed access, and the strip was only used during working hours, so in the evenings and at weekends the strip was clear.
And very strictly, going back to page 511 on the facts,
Yes.
the access was allowed through a defined corridor. So you could possibly say that for everything apart from that corridor, there was exclusive
Yes, I think that's
possession.
right.
It seems that it wasn't the case that access was allowed generally across the land.
No,
It was through a defined corridor.
No. I mean, in this case, there is potential pedestrian access by threading through the boats which are stored. So there is some sort of access, depending on what way the boats are stored, what one can get through. Yeah, I don't say this case is rightly decided, but it hints at the correct test, we say, and is not the test which His Honour Judge Paul Baker...
Yeah, but I mean, when you say it hints at the correct test, it waters it down, doesn't it?
Yeah, well,
in terms of the test you're urging on us, because it says virtually a claim to possession. That's something less than a claim to possession. And again, the word practically, they're claiming. So, I mean, I would have thought that Lord Burroughs is right. You must surely take issue with those qualifications of the test that you're proposing to us.
I do. I would ask this court to disapprove any test which looked at whether it deprived the whole beneficial user. Or we say we've got a much more bright line and principle test, which is whether it deprives the servient owner of legal possession.
Yes, thank you.
Miller and Emser is the right to use a lavatory, and the right granted, it's 707. The right granted is there. It's the words immediately beneath the head note and about 10 lines down, and together also with the right for the tenant to use to the land and sphere of landlords and all persons authorised by them, not a tenants of the land house. The lavatories on the first and second floor. And the Court of Appeal were quite prepared to say that that was a valid easement, and the relevant passage is at 718. Starts at the top, in my judgment, the right at all the requisite characters of an easement. There's no doubt as to what were intended to be dominant, serving tenements, respectively, rights and pertinent, form and calculate to enhance its beneficial use. Through the choice of the dominant owner exercise the right, the owner of the serving tenement will be excluded, but this in greater or less degree is a common feature of many easements, for example, rights away, and does not amount to such an ouster of the servient owner's rights as was held by John Jay to be incompatible with the legal easement in Copeland and Greenhalgh. So that's the way Lord Justice Romer described the test in that case. Perhaps more importantly is Re Ellenborough Park, which starts at 897 of the bundle. Sorry, it doesn't start at 897, but 897 is famously the case which decided that a right conveyed with houses round a square to use the square could be a valid easement, and was considered further by this court in the Regency Villas case. But the relevant right is the top of page 134 of the report's top of page 97, and also with the full enjoyment at all times hereafter in common with the other persons to whom such easements may be granted of the pleasure ground set out and made in front of the said plot of land in the centre of the square called Ellenborough Park, which said pleasure ground is divided by the said Wallace Colt Road, but subject to the payment of a fair and just proportion of the costs, charges and expenses of keeping in good order and condition the said pleasure ground. And that was the right which was granted. And the Master of the Rolls considered, if you go to 926, again, he considers at the bottom, not the bottom, the penultimate paragraph, he recites Dr. Cheshire's modern real property, the 4 qualities of an easement. For the purpose of the argument, that's the paragraph. There must be a dominant servant tenement. An easement must accommodate the dominant tenement. 3, the dominant and servient owners must be different persons. And 4, a right over land cannot amount to an easement unless it's capable of forming the subject matter of a grant.
Which I think is pretty much the formulation that Lord Briggs
That's exactly right, yes.
repeats in.
Lord Briggs described the judgment here as, I think, careful and compelling in this case. But he, if you go to 938,
Just on that,
Yes.
one sees at 4 that the test is that the right has to be capable of forming the subject matter of a grant.
yes,
So, I mean, no suggestion of a difference between acquiring an easement by prescription or by grant.
quite, absolutely. And of course, that phrase, there's a number, as Lord Briggs highlighted in the Regency Villas case, there's a number of different tests within that.
Certainly.
But absolutely,
But the dominant one is, if I'm the landowner, could I grant
that's right.
this right as an easement?
That's right. Well, of course, it's fairly obvious that we would submit that there can't be any difference because the whole point of prescription is it supposes that there was a grant in the past.
Yeah, precisely, yeah.
That's right. That's the whole fiction of prescription. And indeed, well, there's 3 ways. There's express grant, there's implied grant, Section 62, and there's prescription, which is either lost modern. Well, there's lost modern grant is one of the ways, and there's under the Prescription Act. I was taking you to 927, and again, just to show the way that the Master of the Rolls describes it's the next page, and it's the sentence, I think it's about 15 lines down. The exact significance of this fourth condition is at first sight perhaps not entirely clear. As in the original parties to the grant, it's not in doubt that rights of this kind will be capable of taking effect by contract or licence. But the purpose of the present case, as the arguments made clear, the cognate questions involved under the condition are whether the rights purported to be given are expressed in terms too wide and vague a character, whether, if insofar as effective, such rights would amount to rights of joint occupation or would substantially deprive the park owners of proprietorship or legal possession, whether, if insofar as effective, such rights constitute mere rights of recreation possessing no qualitative utility or benefit and on such grounds cannot qualify as easement. So that's the way the roads there expressed, whether and if so far as effective such rights would amount to rights of joint occupation or would substantially deprive the park owners of proprietorship or legal possession. And that comes close, we would submit, to the test that we say is the appropriate one. And the conclusion is at 939. Well, can I ask you to start at 938? We turn next to the last paragraph. We turn next to Dr. Cheshire's 4th condition for an easement. The right must be capable of forming the subject matter of grant. As we've earlier stated, satisfaction of the condition in the present case depends on the consideration of questions whether the right claim is too wide and vague, and whether it's inconsistent with the proprietorship or possession of the alleged servient owners. Again, coming close to the test, if not the test that we say, and whether it's mere right of utility. And the conclusion is just in 2 paragraphs down. Our interpretation of the deed also provides, we think, the answer to the second question. For the right conferred no more amounts to a joint occupation of the park and its owners, no more excludes the proprietorship possession of the latter than a right of way granted through a passage, or than the use of the public of the gardens of Lincoln's Inn Fields, to take one of our former examples, amount to joint occupation of that garden with the London County Council, or involve an inconsistency with the possession or proprietorship of the council as lessees.
I understand just looking at 938, 939, I understand the concept of something being too wide and vague. I understand the concept of it being inconsistent with proprietorship or possession. At least we'll come on to those as alternatives. I'm not quite sure why they're alternatives. But then I'm not sure where the last bit comes from. Whether it's a mere right of recreation without utility or benefit. Where's that come
I
from?
think that was the issue in the case. It was whether a mere right of recreation could in fact be an easement. You see, even if all the other categories were fulfilled, it was a right to recreate, a right to walk and use the gardens, the defined gardens. And I think one of the issues in that case was whether that was indeed a right. Now,
But if I had a right of recreation, I mean, is that incapable of being, I to come onto your land and for recreational purposes, is that incapable of being an easement?
no, it's not. That's the point of Re Ellenborough Park.
Yeah.
And indeed, I think this court in Regency Villas went further. I think a right to use a golf course and a right to use a swimming pool were held to be valid easements. But the principle of a right to recreate over for a landowner over a defined tract of land in the vicinity is that case. Re Ellenborough Park recognised it as being an easement or capable of being an easement. Whereas, for example, Dyson Hay, it had been claimed on behalf of the public in general, and that was found not to be. And I don't think there's anything controversial about that unless you're doing the town and village green rights or rights of, in relation to land that's common land, and there's a statutory right to roam, then you can't have a general right to recreate as a private right on behalf of members of the public.
Just on that, one sees at the bottom of the paragraph you were just inviting us to read on 939,
Yes.
that it's limited to grant rights to a limited number of other persons to come onto it for the enjoyment of its amenities. It seemed to me that was indicated that this Sir Wilfrid Green, sorry, I can't remember who was the... Evershed, Lord Evershed, having in mind the Dyson Hay sort of situation. I mean, it's almost as though in Dyson Hay, the judge had in mind that you could have thousands and thousands of people come on to the land and lie down. He seemed preoccupied, the court seemed preoccupied with people lying down on the meadow.
Well, if you go back to, it's 529, Robert Dyce, a magistrate of Old Aberdeen, brought an action against Lady James Hay, alleging that he and the other inhabitants of New Aberdeen, Old Aberdeen, and the vicinity thereof, and the public generally, had used and enjoyed from time immemorial a certain footpath running along the bank of the River Don, Woods Fence Estate, and furthermore particularly alleging that a certain piece of strip of land ground between the footpath and the river, to the extent mentioned in the pleadings, had been from time immemorial used and resorted to by their pursuer and other inhabitants of the place aforesaid, quote, for the purpose of recreation and taking air and exercise by walking through the same, resting thereon as they saw proper. So it was claimed as a right to the member of the public. So that's not a species of right which exists unless one's dealing with common land or town and village green rights. And even town and village green rights, the recreators have to be resident within a defined area.
Yes, thank you.
And what is the difference between possession and proprietorship, if there is one?
Well, we say the proper term is legal possession, which is proprietorship is, I suppose, is an adjective to describe owning something. You could be a freehold proprietor of land or a leasehold proprietor, but it's legal possession. Proprietorship, I suppose, might be said to be the ownership of those rights or certain rights. And proprietorship here, we would submit, is a synonym of legal possession.
And is legal possession, in your submission, synonymous with exclusive possession? I mean, what exactly are you adding when you're adding what exactly do you mean by legal possession?
Well, legal possession, I'm coming to that, but legal possession is that relationship to either a freehold or a leasehold, which involves the rights themselves. It is to say you have exclusive possession. Yes, you do. I suppose if you are a freeholder or a leaseholder, on the face of it, you have exclusive possession. So that is the badge of it. But you can give away exclusive use. For example, if I'm a freeholder, I can grant a lease of my freehold, which grants exclusive possession to the leaseholder. That becomes a separate legal estate in land. And if I'm a leaseholder, I can then grant a license to someone to use my land, and that might...
Well, you could also grant a sublease.
You could, but you could also grant a license. For example, if I'm a leaseholder of a hotel, I have exclusive occupation of the hotel. That's by definition, I'm a leaseholder. I then can sub-license the rooms to various guests who have exclusive use of the rooms for the night. But that's not an interest in land, the license.
But is your contention in fact encapsulated within the concept of something being inconsistent with proprietorship, if by proprietorship you mean the freehold estate or leasehold estate?
Yes, legal possession. If proprietorship is used as a synonym, I mean, I suppose you could be, proprietorship again is an inexact, because you can be proprietor of a business or something like that, but if proprietorship is used as the holder of the legal estate or the freehold estate or the leasehold
But in landlord terms, proprietorship means the holder of property interest, doesn't it? It's property interest.
Yes, yes. But they talk of property interest, yes, or property estates. But in this context, when they're using possession or proprietorship, we say what they're getting at is legal possession. It deprives the servient owner of legal possession of the land.
And what does control add to that? Does control add anything?
Not really. And Lord Scott was, I think what Lord Scott added possession and control.
Yes.
I think his point was you have possession implies control, but if you grant an easement out of land, then you lose control to that extent. I think that's what he means, but we say legal, it doesn't add much, because if you're talking about an easement over land, then yes, you lose control to that extent. Looking at the time, my lords, we've dealt with, there's Thomas Ward and Alexander Bruce. That's the case where the Court of Appeal were prepared, albeit obiter, to hold that a right to scuttle or break up ships in a dock belonging to another could be an easement, but an ancillary right to, quote, maintain the silt over the area to which the right was alleged to extend at a height chosen by the appellant as convenient to themselves could not be an easement. And that's at 1001, and their comment was it involves an almost complete exclusion of the alleged servient owner, involves also the result that over the last 30 years the appellants have been entitled to all the area over which the right is said to extend, altering its nature by tipping material on it and curtailing its height, and thereby altering its extent and character. Ward and Kirkland, and this I've never known how to pronounce. Is it Ungood Thomas, James? Justice Ungood Thomas. I apologise to anyone who might be offended by my mispronunciation of that. That's page 1034. He held there, unsurprisingly, that a right to enter a neighbour's land to repair a wall could be an easement. It was argued, relying on Copeland and Greenhalgh at page 1049, that a right which excludes the owner from exclusive possession of his land cannot be an easement. And the judge concluded at page 1062, the objection which is taken to such a right as this constituting an easement is that, so it is said, it would amount to an exclusion of the servient owner from the possession of his land. And then he said, he was quite clear that the right which was claimed, that is the right to go on to someone else's land to maintain a wall, such a right as is claimed here is not a right that would be defeated upon the ground that it would amount to the possession or joint possession of part of the defendant's property. And that's at 1063. Grigsby and Melville was a case, and that's at 553, where Mr. Justice Brightman held again, albeit obiter, that an easement of unlimited storage within a confined or defined space was not capable of being an easement. He says at 562, an exclusive right of user over the whole of the confined space representing the servient tenement was the right claimed, and it couldn't be an easement. So, in summary, before one gets to London and Blenheim, we would say that there's nothing in the case law which establishes the Ouster Principle as set out subsequently in London and Blenheim. In Re Ellenborough Park, Lord Evershed referred to a right which would substantially deprive the park owners of proprietorship or legal possession, and in Copeland Greenhalgh there was a right which is virtually a claim to possession. Now, I accept that those...
You added the word legal.
I'm sorry. I apologise if I've misquoted.
Well, I don't think the word legal appeared in the quote.
If that's right, sorry, that's my notes. I was reading from my notes.
I was picking up Lord Burrows.
I've already quoted you that, and I don't want to mislead. And the point is that the test that their lordships were applying in those cases is different from the test which was subsequently applied. Now, London and Blenheim, the issue was whether a right to park which had been granted benefited subsequently acquired land. If you want to look, it starts at 638, and if you want to look at the relevant clauses, it's at 640. There's clause 7, which is at letter F, and then there's clause 11, which is at the bottom of the page and over the page. And the issue was whether A, the effect of clause 11 was to allow the right in clause 7 to benefit after acquired land, and the judge held that it couldn't, and that was upheld in the Court of Appeal. The second issue was whether clause 7 could, which was a right to park if any space is available on any part of the retained land set aside as a car park for benefit of customers, clients or employees of any retail shop or other business conducted on the retained land for the benefit of the members of the public on the like terms. So it was a right to park in a designated parking area. And the second right was whether that was a right recognised by law. The judge found against the claimant on the first issue, and it was 645. Yes, 644, I'm sorry. And the last line there, or the last sentence, my judgment on the first issue is sufficient to dispose of the case, but I should go on to consider the remaining issues which have been extensively argued before me and which relate specifically to the right to use the car park. These are whether the right to park conferred by clause 7 can exist as a valid easement, whether the serving owner can terminate or modify the right by changing use of the serving land. So William Goodhart arguing for the validity of clause 7 as an easement began by taking through a number of cases in which a right to park vehicles considered. He started, however, by referring to the well-known dictum from Lord Shelton, Vernon, Attorney General, and in the southern Nigeria case, which you already read. And he deals with a number of cases, and then he reaches his conclusion at 648. And I'm looking at the letter B, between the letter B and C. That leaves the main point under this head, whether the right to park cars can exist at all as an easement. I would not regard it as a valid objection that charges are made, whether for the parking itself or the general upkeep of the park. The essential question is one of degree. If the right granted in relation to the area over which it is to be exercised is such that it would leave the servient owner without any reasonable use of his land, whether for parking or anything else, it could not be an easement, though it might be some larger or different land. And those are the words which have been applied since. Now, a number of points we would make to that. One, fairly obviously, along with the entire discussion as to whether a valid easement of parking can be a valid easement, it's obiter. It's considered, but it's obiter. Indeed, we would say it's obiter heaped on obiter, as he was prepared to recognise the right. He would have been prepared to recognise the right to park as a valid easement, and therefore it wouldn't have fallen foul of the test that he put forward. Secondly, it's not the same. I've been banging on about this, I'm sorry, but it's not the same as any of the tests which had been applied, whatever they were, by the judges in the previous cases. It's not the same as Mr. Justice Upjohn had purported to apply in Copeland and Greenhalgh. It's not the same as Re Ellenborough Park. A test which asks whether the right claimed is such that it leaves the servant owner without any reasonable use of his land is not the same as a test which asks whether the claim amounts to a successful claim of possession or is virtually a claim to possession of the servant tenement, necessarily the exclusion of the owner. And the test which he put, which His Honour Judge Paul Baker sets out there, is not really derived, we would submit, from any previous case law.
Also,
but it's,
what does he mean if the right granted would leave the servant owner without any reasonable use of his land, whether for parking or anything else? As I understand it, if in this case there was an easement to park your car, you could just put your car there.
Oh, well, it's clause 7, the easement that you're dealing with in this case is the one I've just read. It was an express granted, it's clause 7, 640, my lord.
Thank you.
Maybe I haven't been clear. It's clause 7 at letter F. When the transfer is developed as being completed or otherwise, it may be agreed by the transfer a right for customers, clients or employees of any retail shop or other business conducted on the transferred land to park, if space available, on any part of the retained land set aside. So that's the expressly granted right.
So what were the facts? Was there a sort of general parking area which could accommodate a number of vehicles?
It was, if you look at the head note, it was a development agreement. And what happened was there was the right granted in favour of certain land over other land on which a car park was to be constructed. Now, by clause 11, see that clause 7 grants the right in favour of the transferred land on any other shop or other business conducted on the transferred land to park. But by clause 11, in the scheme of the expression, the transferred land shall include any other land if A, such land is capable of being benefited by the right hereby granted, B, notice is given to transfer or within 5 years of the date of that any such land is to be included. So what purported, the right granted in clause 7 purported to be granted for the benefit of the land actually transferred, but also for the benefit of after acquired land, i.e. any land that was transferred land which included any after acquired land which was notified within 5 years. And it was held that that couldn't take effect because there was no dominant tenement in respect of that, or it wasn't part of the dominant tenement at the date of the grant. I think and that decision was upheld by the Court of Appeal. A subsequent, a subsidiary or secondary argument was, well, in any event, the right under clause 7 is not a valid easement, and that's the one that His Honour Judge Paul Baker deals with in the part of the judgment to which I've drawn your attention. Is that?
Yeah, I mean, I was just slightly puzzled by what he says at page 648, because he seems to contemplate there that you could have an easement to park
Yes. Oh, yes, he does. He owns it. You can.
Right. On the basis that does not leave the servient owner without any reasonable use of his land.
Yes.
And my puzzlement arose out of the fact that, well, if I park my car there, obviously I'm preventing anyone else from
I think
parking their
the
car.
issue here is this was a right to park on a large area.
That's what I was asking.
Yes.
So,
Oh, yeah. Oh, I'm sorry. In which case, I'm sorry. I haven't.
right. So it's a general parking area, not. So is the judge here seeking to indicate that if there was an easement in relation to using some specified parking space, or purported easement, that could not be an easement?
He's not dealing with that at all. He doesn't specifically deal with that at all. All he does is the argument. If you look at 641, I think. If you look at the paragraphs out on 641, sets out the history. But if you look at E, by October 1990, a substantial car park had been laid out in the retained land. The fourth and final issue is whether the power given by Clause 11 to add land to benefit from the scheduled rights can be exercised so as to bind successors and title of the retained land. This is by far the most difficult issue, and I shall take it first. That's the issue which he decides against. So we're dealing with the rights in respect of a substantial car park. And all he does is address the argument obiter that whether the right to park can be an easement at all. And he says it can, provided you don't deprive the servient owner of any reasonable use.
But, I mean, my Lord's point is, I think, this isn't it. If you have a big car park and you grant a right to somebody to park a car or a limited number of cars, you don't, in any event, deprive them of the ability to use the rest of it.
Yes.
If you had a designated parking space and said, I grant you the right to park in that designated place, that might raise different questions, because when somebody does come and park in the designated place, you can't park there.
Well, quite. That's the issue.
Yep.
And that's what's contemplated by, as we'll see, in Moncrief and Jemison. If a right to park one car in an area that is large enough to hold 20 cars, that can be an easement because you're not depriving them of reasonable use. What about a right to park 5 cars in the same area? Or a right to park 1 car in an individual space? That's the perceived difficulty with the reasonable use test. We say, as a matter of principle, there's no reason why you cannot validly grant an easement to park a single car in a particular space. There's no reason in principle why the law should strike that down. But if you apply the reasonable with test, then you can validly say, well, there's no reasonable use while the car is parked. Suppose I park a vintage car there with a cover, and it's there most of the time. I take it out 3 days a week or 4 weekends a year. Oh, sorry, 4 weekends a year. Is that not an easement because my car is stationed in that individual place?
Well, I mean, but the whole point is, if I grant you a right to park your car in that designated space, I mean, by definition, in order to stand by my contract, I can't park my car there.
No, you can't. That's right, but that's the question. Whether, if the argument is that, A, that should be a right recognised as an easement. These are rights frequently granted, and you can either do it, I suppose, by leasing the space or transferring the freehold of it, but there's no reason we say why, as a matter of principle, you shouldn't grant an easement to park there. But if you apply the test of whether it deprives the owner of reasonable use, the risk is that it's not a valid easement, because you're looking at it's a value judgment depending upon, I suppose, the nature of the car park, or the physical nature of the car park. If you apply the test of whether it deprives the surveyed owner of legal possession, then we say it's much clearer because it doesn't in that circumstance. But suppose that
The reasonable use involves the question of degree, and you say that's unclear and unsatisfactory.
that's right. And it involves a value judgment. What is reasonable use? I mean, if you go to Verdi and Chana, one of the case my learned friend relies upon, it's a first instance judgment of his honour judge power. I think it's an appeal of his honour judge power. But you know, that dealt with a car parking space. Now you can say, well, you can run pipes under it, wires under it, wires over it. It was considered you could put trellises on the side of it. You could get access to. So you're thinking of whether that's a reasonable user or not, and that's a value judgment. I mean, Lord Snowden shakes his head and thinks, well, that's probably not a reasonable user.
I think as Lord Hanlon probably has indicated, I mean, it gives rise to all sorts of bizarre hypotheses as to what you might or might not do.
Yeah, well, I mean, I'm sorry.
I mean, the sort of question that was in my mind, which probably is raised by this, is, you know, if I say, well, there's a designated parking space, you can use it, you have exclusive use of it during the working week, and otherwise I can use it.
Yes.
And you say that must be capable of being an easement.
Yes.
Even though during the designated periods, I can't use it.
Well, you can
walk
use
round it.
You can
walk round the car.
I suppose that. You can use it for parking. You can use it. You can't use it for parking cars. I suppose you can resurface it. You can put things under it. It depends what you. That's the point. If your test is use, that's a much vaguer test as opposed to possession, which says, well, looks at the bundle of rights you've got. Now, there's a difference between, as Lord come to it very shortly. There's a difference in what Lord Scott says. There's a difference between sole use and occupation on the one hand and legal possession on the other. I can be in sole occupation of someone's land and be a mere licensee and not necessarily have legal possession at all. I'm sorry if I'm not making myself clear, but you've hit the nail on the head. There's no reason we say why a right to park a single car in a designated parking spot shouldn't be an easement. There's no reason why a right to store a boat similarly in a similar space shouldn't be an easement. It doesn't deprive, if your test is legal possession, which is a much more bright line and clear-cut test, and what the one suggested in Moncrief and Jemison and by the Law Commission, then you allow those rights to be easements, and you have a less vague test based less on value judgment as to what is or is not reasonable user. I was going to take you to the passage in, I think it's 105 of, where's 105 of Ted Johns? Of forgive me a minute. Okay. It's just, that's right, it's paragraph 109 of the Upper Tribunal judgment, Justice Edwin Johnson. And it's at page 88. It appears that what the judge has said, it is clear, as I think Lady Simler has already indicated, that on the facts that pedestrians can walk their way through this. But nevertheless, there, the first tier tribunal and then the upper tribunal came to a value judgment that that wasn't reasonable user. Yeah. Now, that's because on the facts, you can walk around it. So no pedestrian is going to weave their way through the boats if you can actually physically walk around it. But suppose exactly the same right had been claimed over a much narrower strip of land. Suppose that there was no way round.
Well, just like the parked cars.
That's right, on the fact. Suppose that, but so the pedestrians had to wend their way through. Might have been slower, but maybe marginally less safe, I don't know. But then presumably on that value judgment, that would have been retention of reasonable user, because the pedestrians would have been forced to use walk over the triangle, even with the boats there, to get access from one side to the other. But we say that whether or not your right to park or whether or not your right to store a boat is an easement should not depend upon a minute examination of the facts and the geography.
And the value judgment that's inherent in that.
Yes. One needs certainty in this area of law. I entirely accept that if you're dealing with certain areas of the law, for example, the question of whether a landlord has unreasonably refused consent to assign a lease is peculiarly fact-sensitive, so the outcome depends upon all the facts. But question when you're dealing with whether or not a right granted is an easement, we say it's not desirable to have that to be overly fact-dependent. Certainty is required. And to have a test which decides that this may or may not be an easement depending on the facts, depending upon the geography, and depending upon the value judgments of whoever's making the decision, is not desirable.
Now, Mr. Holland, you just need to be aware of the time.
Yes, I am.
We're
I'm very aware of the
concerned
time.
that you've got
Very
a
aware.
certain amount more to get through.
I have to take you to Batchelor and Marlowe, because we say it's not authority for anything. If you look at, it's at 424.
You say it was common ground.
Exactly. It's common ground. If you look at paragraphs 8 and 9, paragraph 8 he sets out the London and Blenheim test. Paragraph 9 is common ground before, so there was an essential question in this case, no authority answer. And then he looks at various other two cases, Dyson Haycombe, we have paragraph 13, 423. In view of the fact the parties agreed what the right question is and the answer to it depends upon facts in each case, I need not grapple with these arguments, other than say I think it's clear from his judgment that it's just up to reject the claim because the right is certainly uncertain and too extravagant. Then there's mentioned London Blenheim at 15, at 424. After that short diversion, I return to the question which has to be answered in this case. Doesn't exclusive right to park cars for 9.5 hours every day, leave the plaintiff without any reasonable use of his land on the parking house. That's the test he applied. Now, our friend jumps upon the last sentence of paragraph 18. He says such a restriction would, I think, make his ownership of the land illusory. And that, my learned friend picks up in his written case. Now, in my submission, however Batchelor Marlowe has been treated in subsequent cases, we say it's not authority for anything. It was the application by, I imagine Lord Justice Tuckey would be surprised that if anyone said he was elucidating a matter of principle. It was the application of facts of that case to a test which had been agreed, and that test was the London and Blenheim case. And whatever arguments were rehearsed before the court, there's no critical examination in his judgment of the Ouster Principle or what it should be. He simply accepts what the party, rightly, what the party said was the applicable test. And the test applied was the London and Blenheim test, and the comment, such a restriction would, I think, make his ownership illusory, is, I'm not saying it's a throwaway comment, it's a comment, but it doesn't amount to Lord Justice Tuckey putting a gloss on the test that he had been asked to apply and agreed to apply.
So, just going back to paragraph 10 and the quote from Gale on easements.
Yes.
I had some problem with the way that it read at the start of that. An easement involves a diminution of natural rights of ownership, and a grant under which the proprietary rights of the so-called servant owner are either shared or usurped cannot create an easement. Has something gone wrong with that quote or the extraction? Because I don't really understand those two bits.
I'm not sure about that, is the answer. I think we can get the current quotation on the current...
Well, if an easement involves a diminution of natural rights, or a diminution of natural... I thought the whole point was that you're saying if you have rights, if there is a, quote, diminution of rights of ownership.
I thought it was an exclusion of rights of ownership. Diminution, it's obvious.
Is all right, but exclusion isn't.
Yes, yeah. I mean, the point is, the test that we argue for is that whether looked at as a whole, the rights deprive the servient owner of legal possession. It's clear that an easement is a diminution of those rights because you're giving someone else the right to park a car or to walk over your land.
You can't go on as landowner and say, get off my land.
No.
That's the whole point of the easement, is they can say, I have a right to be here doing this thing.
But you can say, get off my land if you're doing something that's not allowed by the easement.
Yeah, of course, yes.
If you have a right on foot and you drive a car, I can say, get off my land because...
On my Lord's question, I mean, I rather read that the first sentence of Gale as drawing a distinction between all easements involve a diminution of natural rights of ownership in the sense that I've just said. But if it goes beyond that, and the rights of the servient owner are either shared or usurped, in other words, taken away essentially completely, then you can't have an easement for that.
Yes.
I didn't read it as being problematic in terms of the arguments that we're addressing.
Well, we say the correct test is the deprivation of legal possession.
No, I understand.
My Lord, we accept that there has been cases since Batchelor and Marlowe have treated it as authority. We say wrongly. It's right now to look at Moncrief and Jemison, and I'm very conscious of the time.
So those cases they're referred to in your case, are any of them Court of Appeal cases? Or?
No, there is one Court of Appeal case, which my learned friend is Jackson and Mulvaney. Okay. Most of them are first instance.
Yes. Well, I think we don't need to look at those to understand the point that you're making about
I'm grateful.
At Moncrief, I think we do need to look
yes, and it is at page... it starts at 725, and just to... conscious of the time, if you want a summary of the facts, or the relevant facts briefly, if you look at paragraphs 2 and 3 in Lord Hope's speech, which is at page 727, basically a house at the bottom of a escarpment by the sea. The only access is a steep road. A right-of-way granted over the steep road to just outside the property. The question was whether that right-of-way involved a right to park, not just to stop, unload and unload, but to park more generally. And the House of Lords upheld the lower court's finding that in the peculiar circumstances of that case, such a right did arise. One of the questions being argued was whether the right to park could be an easement at all. It's a Scottish case, so we're dealing with servitude. But 2 and 3, at paragraph 20, Lord Hope, which at 732, Lord Hope sets out the issues, and there's a more expanded list of issues at paragraphs 105 and 106 at 760 in the speech of Lord Neuberger. And there are 3 passages from Lord Scott's judgment which I would draw your attention to. The first is at paragraph 47 at 740. And I would ask you to read 47 down to 2636D. That is down to the sentence which begins a second necessary qualification.
Yes.
At 745, he describes the side note in Dyson Hay as unhelpful. And I'd ask you to read paragraphs 54 and 55.
Yes.
And I note the phrase in letter G, sole user as a concept is quite different from and fundamentally inferior to exclusive possession. And then finally, at paragraph 59, 747. So that's 59 and 60.
Yeah, so at 59 we see Lord Scott saying, I do not see why a landowner should not grant rights of a servitude character of his land to any extent that he wishes. So that's tying it back to what can you do as owner of land by way of grant of easements for others.
Yes.
He relies on and refers to an article by Mr. Hill-Smith.
Yes. It's
And that's to similar effect, is it?
Yes. We haven't given
You haven't
it
put
so
that in, no.
Sorry, that's not in our bundle of authority.
It's not.
I think it would be helpful if we could be supplied that
Yes.
in electronic form after the hearing, please.
It's 2007 Conveyancer 223. It's 61 as the reference. Lord Newburger, again, if you go to 768, I would ask you to read, I'm not going to ask you to read now, but all of paragraphs 139 to 144 of what Lord Newburger says. But at paragraph 40, 140, he says, at least as presently advised, I'm not satisfied that a right is prevented from being a servitude or an easement simply because the right granted would involve the surveyed owner being effectively excluded from the property. And at 143, he says, accordingly, I see considerable force in the views expressed by Lord Scott in paragraphs 57-59 of his opinion, the fact that a right can be an easement, notwithstanding that the dominant owner effectively enjoys exclusive occupation. Basically, the essential requirement is that the surveyed owner retains possession.
Yes.
He's not as definite as Lord Scott, and he expresses some reservations. I'd also draw your attention to paragraph 76 at 752 of Lord Roger, where he points out in Scotland there's a servitude of aquahistus and aqueductus, where the dominant owner may construct a permanent dam on the servient land at the source and then lead the water from there through pipes permanently laid over the servient tenement. Again, that's a Scottish right. And Lord Hope at paragraph 24, 733. My lords, I'm trying to canter more quickly. The next one is the Law Commission. Again, I'd invite you to read it. It's at 1278. Is the conclusion. It's paragraphs 3206 to 3208 on page 1278. If you want to read the entire discussion I invite the court to read all of paragraphs 3.188 to 3.211, but the meat of their recommendation is at 3.206 to 3.208, and they produce a draft bill, the relevant clause of which is clause 24 at 1282. Use of land is not prevented from being of a kind which may be the subject of an easement by reason only of the fact that it prevents the person in possession of the land from making any reasonable use of it. That's their suggested bill, but with respect, this court there's no need for a bill because, as I pointed out overly long ago, now this is judge-made law and that there's no need for that. It's for this court to declare what the Ouster Principle is.
Yes.
Commonwealth authorities, I'll skip over those. In Australia, a case called Tunison and Barter, it appears that the Australians have adopted what Lord Scott has said, a test akin to that we propose. And if you look at 1148, paragraph 140, and 149, paragraph 149 at 1150, the New Zealand and Canadian position is less clear-cut near the English position. There's a case called Schmuck and Opua Coastal Preservation, and we've cited the relevant passages there. And in Canada, there's a judgment of the Court of Appeal in British Columbia, Robinson and Pepito, and we've cited it there. So there's difference. Criticisms, fairly obviously, we say the current test is vague and the outcome unpredictable, particularly in relation to parking and storage easements. It involves the court or whoever decides it making value judgments, and it risks striking down rights which, if one takes up what Lord Scott has said, as Lord Sales noted, risks striking down rights which ought to be easements. The same point was made by the Law Commission in paragraph 3207 at 1278. There's no reason in principle why there can't be a right to park a single car in a space sufficient to hold only one car. There's no reason why that shouldn't be an easement. No reason why a right to store coal in a coal shed shouldn't be an easement. There's no reason why the right to store goods or a boat within a defined area should not be an easement. And the better test, we say, is one of legal possession.
Just to understand what you say the test should be.
Yes.
The Australian authority you referred us to talks about the question of whether a putative easement substantially deprives the servient owner of proprietorship or legal possession to such an extent as to be inconsistent with ownership. Which bits of that do you should be adopted or not?
We would submit that the proper test should be whether the putative easement deprives the servient owner of legal possession. So that's a bright line test. We submit that introducing terms such as proprietorship or substantially again risks
or to such an extent as to be inconsistent with ownership. You say that's all too woolly.
Well, it's not woolly. It's within the test. If you are deprived of legal possession, you are deprived of ownership. If ownership is equated to having legal possession.
But the Australians seem to think that legal possession you can be deprived of legal possession to an extent which is not inconsistent with ownership. Well,
I submit that that's not what they're getting at. I think what they're getting at is I'm sorry, it's not for me to accuse the judges in Australia of being vague, but we would submit that the better test is simply to say, look, does this right deprive the servient owner of legal possession? And it either does or it doesn't. And there's a bright line. It may be difficult to draw, but there's a bright line that whether it does or doesn't. And uses of phrase like ownership
But they don't think that they do have a bright line test because they go on to say that assessment is a matter of fact and degree.
Yes, and my point is one needs to be cautious in this area of having a test which depends upon fact and degree for reasons that I've already submitted. One needs a degree of certainty here. There's obviously going to be difficult cases, but the courts are, and I'm moving on, and I'll deal with it very brief. Courts, the term legal possession is well known in the law of property in a number of different respects, and we set it out there.
So you look at it from the point of view of the servient owner,
Yes.
not the dominant owner.
That's right. Well, I mean, that chimes with, I think, what Lord Briggs said in the Regency Villas case. We said that you don't look at what the dominant owner can do on the land. And the point about the Law Commission were making is that they say since Street and Mountford, the test is what the servient owner can do and not what the dominant owner can do. Or you look at what the dominant owner can do through the lens of what the servient owner, what it leaves the servant owner being able to do. I mean, the Batchelor and Marlowe test it looks at the servient owner as well, doesn't it? It says, does it deprive the servant owner of any reasonable use? So you're looking not at what technically what the dominant owner does, you're looking at what the servant owner is left with. So we don't say you change that, you just have a different test.
Isn't a slight problem with your test that we then have to understand what's meant by legal possession? I mean,
Yes.
it's not, to many people, a particularly transparent idea. So one would then need to elaborate on what's meant, wouldn't one?
Well, one does, it doesn't because it's already done for you. If you look at, we set it out in our written case. There's a clear legal distinction between occupation and possession that's well recognised. Now, if
Sorry, which paragraph of your case are you referring to now?
Give me-
'58, is it?
Yes, 58 onwards.
Yes, thank you.
And, I mean, even some, such an authority as Lord Newburger himself, and we take you to a Keachy and Buckland, which starts at 377. But if you look at, and that was a case where someone was said, there was a Section 146 notice served forfeiture, and it was said that they'd shared possession. And in fact, they'd shared occupation, but they hadn't shared possession. And Lord Newburger, at paragraph 23, which is at page 383, says this: the difference between possession and occupation is rather technical, and even to those experienced in property law, often rather elusive and hard to grasp. Nonetheless, it is very well established, and is particularly important and indeed well known in the field of landlord and tenant law, especially in relation to the question of whether an agreement creates tenancy or licence, and in relation to alienation covenants such as clause 14. So, and we set out there that there is, it may be difficult to draw a line, but legal possession has a clear established meaning, and courts are well used to deciding whether, for example, looking at an individual agreement, it grants its legal possession or not.
But aren't you talking in that whole section about possession? But you've inserted the word legal possession.
Yes, well, possession has a legal meaning. That's what we say. It's easier to say legal possession. We cite from Mark Wonacott's book, Possession. He says, look, there's a mix-up. You can use you can use possession in three ways. You can use it to mean legal possession, that is the acquisition and the holding of the rights of a freeholder or leaseholder. Or you can use it in what he describes as the vulgar way of meaning just occupation. Or there's constructive possession. But when I say legal possession, what I mean is to ensure that one's using it in the first of those senses and not as a synonym for occupation. Because you can say, I'm in possession of land, I'm in occupation of land, and frequently people will, indeed lawyers and judges will occasionally use one as a synonym for the other. But as we make the point there, legal possession is a distinct phenomenon, distinct concept in property law, and courts are however difficult, well used to deciding whether, for example, an individual agreement grants legal possession or doesn't.
Right. So if I say to you, I grant you exclusive right to use and possess this car parking space every day of the year except Christmas Day, how does that work? How does that fit within your test?
The court would first of all have to construe what was granted and then decide whether you can categorise it as the grant of a freehold, a lease, or an easement. But there's or a licence. I mean, the point is the difficulty of ascertaining into what category a particular agreement falls doesn't negate the fact that you need a clear, bright dividing line between one type of category or one category and another. So suppose, I mean, you've got the differences. The difference is the Riley case, exclusive use of this passageway. The court construes that as a transfer of the passageway. I give you a right to use this car park for £5 a week for 2 weeks. That's maybe a lease, probably a licence. But in the what you've said, right, I grant you exclusive use of the all but the except for Christmas Day.
Yeah,
you say that's
exclusive possession and use.
That's right. Well, but then you have an exception. You can't use it on Christmas Day. Now the court would have to construe: does that mean that this is not what would otherwise be the transfer of freehold? That's the point, but it doesn't obviate the test. It doesn't mean you ignore that you need the fact that you need a test. I'm sorry, I'm maybe not being very clear. It's a difficult question, but you would have to have it.
I mean, I sort of understand you're saying if we just use the word legal possession, everybody knows exactly what that means, and it's really clear, and it shouldn't be a problem.
Yes.
And
it may be difficult to decide whether an agreement grants legal possession, but it's a clear, bright line test. It doesn't involve any value judgments. It's either...
It's the interests in section 1.1 of the LPA.
That's right, and the difference...
And that's what you're saying.
That's right, it's 1.1, and the difference between 1.1 and 1.2.
Yeah.
I'm sorry, I haven't really answered that right. That's factoring in Lord Snowden's question there, but you'd have to decide on the present test, you'd have to decide whether it deprives the owner of any reasonable use. On my test, you'd have to decide whether it deprives the surveyant owner or the transferor or the grantor of legal possession.
Yes, now, Mr. Holland, you're at the limit of your time for opening the appeal. You can go on, but you need to be aware that
I'm simply going to make 3 points. First of all, there is no difference between an easement acquired, or there's no difference as far as the application of the Ouster Principle, whatever it is, between an easement acquired by prescription and one acquired by express grant or implied grant. My learned friend cites from paragraph 23 of Jack's Law and Mulvaney, which is at 58. All that does is point out that there is a forensic...
What was the bundle reference for Jack?
It's paragraph 57 at... He cites, it's 572.
Thank you very much.
Is the reference. But all the court is there pointing out is that there's a difference in forensic task between, if you've got an express grant, all you do is construe the express grant. If you're dealing with prescriptive easements or Section 62 easements, you have to look at the background fact to decide what right was granted.
Yes.
We say if you apply our test on the facts of this case, it is clearly a right which is recognised and should be recognised by the law as an easement, whereas during the winter months our boats are stationed on this land. It doesn't deprive in any way, it can't be said to deprive the respondent of legal possession of the land at all. And can I just finally deal with what appears to be my learned friend's suggested test? In paragraph 23, 34, 51, he says, he mentions the reasonable use test when coupled with the rendering of ownership illusory. So he appears to run together the London and Blenheim test and that comment in paragraph 18 of Lord Justice Tuckey's judgment, and I make a number of points. One, it's not clear if what the respondent is saying that is the test or whether it should be the test. Secondly, it's not the test applied by the judges in the tribunals below. Thirdly, it's not the test applied in Batchelor and Marlowe itself, if you look at paragraph 15 of Lord Justice Tuckey's judgment. 4, it's not the test applied by any court since Batchelor and Marlowe. 5, it's not clear whether the two limbs of this suggested test are cumulative or alternative. 6, it's not merely a slight clarification, which is the phrase used in paragraph 78 of Miller and Friends' written case at page 62. It introduces a further value judgment. Not only does one have to decide whether or not the use left is reasonable, one also has to decide whether or not the ownership is rendered illusory. 2 value judgments. 7, it's difficult to know what is meant by ownership in any event, legal possession or physical occupation. 8, on one view, you might say that the test of ownership being illusory is the same as the test we propose. Does it deprive the surveyed owner of legal possession? And we say if that's right, well then you should just have the test we have. You should ignore the previous part of the test. And 9, finally, even if we're wrong and that is the test, i.e. deprivation of reasonable use and ownership illusory, we would submit that the appeal should succeed in any event, even if that is the case.
Yes.
Those are my submissions.
Yes.
I'm sorry I've gone over my
Well,
time.
just so you know, by my count, you've used 5 minutes of your reply time, so...
I'm grateful for that. I'd rather do that now. Thank you.
Yes. So, Mr. Ward.
My lord, I believe you were expecting to hear...
Oh, yes, I was. Yes, of course. I'm so sorry.
My lord, I'm very conscious that I'm trespassing on Mr. Ward's time.
Yes.
I'm going to...
In fact, what you're doing is you're trespassing on...
Well, indeed, I suppose one follows as night follows day, in
Yes.
which case I'm going to take my submissions at a canter, and it'll be a very quick canter, if I may. I'm going to be addressing you on ground 2. If I could please invite your lordships, your ladyship, to turn to page 43 of the bundle. At page 43 of the bundle, at paragraph 70, you see the submissions that are put so far as ground 2 is concerned. We are working on the assumption for these purposes that the Batchelor and Marlowe test is the correct test, and there are 3 specific criticisms of the manner in which that test has been applied by the judge and the FGT. The test, again, just to reiterate, is to ask whether, as a matter of fact, the facts as they've been held by the FGT and the upper tribunal would leave the respondent without any reasonable use of the specific servient land, which is referred to as the triangle by Mr. Justice Edward Johnson in his decision. The 3 criticisms are: the first is that when answering that question, the judge was wrong to exclude the period from the 1st of June to the 30th of September, which is the period during which the easement itself is not being exercised. There are no boats stored during the summer months. They are left out on the moors. The next is that the judge was wrong to discount potential alternative users because there was no such evidence of such use being made. And the final one was that the judge was wrong to discount potential alternative user because they were unlikely to materialise given the features on the surrounding land. The structure of these submissions, as I say, I'm going to keep them very briefly, as I'm going to go to the judgments in question. I'm then going to go to the relevant documents, finally the law, and make brief submissions. The judgment itself, if I can invite you please to turn to page 86, paragraphs 98 to 100 on 86. The judge below discusses why it is that when one is considering whether the respondent is left without any reasonable use of the servient land, one excludes the summer months. And at 99, the conclusion that he arrives at is simply that because the easement itself is only exercised during the winter months, then one is asking whether the effect of the easement is to deprive the respondent of any reasonable use of the triangle. One excludes the summer months. In other words, it is simply linking the period during which the easement is operative with the question as to whether there is any reasonable user of that. That's the discussion at 98 at 100. And at paragraph 100, the judge recognises that the Court of Appeal in Batchelor and Marlowe didn't actually exclude the period when the car parking was not taking place from its discussion, but draws a distinction between this case and that case, because, and I quote, the easement which was claimed in that case was not intermittent in the sense that for a certain period of year it did not apply at all. So that was the distinction between why it was the Court of Appeal in Batchelor and Marlowe took out the non-user period when identifying the answer to the question, but the same shouldn't apply here. So far as the second, this is ground 2B, is concerned, the judgment at 118, this is at the bottom of 89, states in the fifth sentence, so far as utilities are concerned, I was not shown any evidence that utilities did run under or across the triangle, and there's no reference to this in the decision. The particular focus of paragraph 118 is the judge saying, I don't take into account these potential alternative user because there's no evidence of that user. And I quote, I was not shown any evidence that utilities did run under or across the triangle. So far as the third is concerned, this is the third of the challenges, paragraphs 108 and 109 on page 88. At 108, the judge accepts that one focuses on the servient land when answering the question put in Batchelor and Marlowe, but 109 says, whilst the FTT did conclude that the pedestrians could cross the triangle, the FTT was right to conclude that there was no reasonable user accruing to the respondent as a consequence of that because of, in a sense, the surrounding features of the land. In other words, whilst pedestrians could go through the boats, as a matter of fact, they didn't need to because of the surrounding land. I'm now, if I may, just going to take you to the FTT judgment that puts a little bit of flesh on the bones. At page 108 of the FTT judgment, at paragraph 11, Judge Colin Green concludes at paragraph 11, or makes findings of fact, so to speak, that the respondent in the past has resurfaced the triangle, in other words, resurfaced the servient land, replaced stones with a white line and subsequently a blue line, and I'm just going to make reference to the white line and blue line in due course, marking off one side of the boat storage area. So that's paragraph 11, which are the factual findings of what it is that the respondent has done with land. On page 117, paragraph 44, the FTT judge makes the point that the boats that have been stored have no effect on the public's right to park because there's no demand for parking during the winter, and the respondent in the past has granted the right to store gigs in the triangle during the summer months. So again, we've got user there of what it is that the respondent has done on the triangle of land during the summer. At paragraphs 16 and 18, if I could just ask you to come back to 16 and 18 just to add a bit of context so far as the storage of gigs is concerned, at page 109 on 16 to 18 is the first-year tribunal's discussion of the fact that the respondent during the summer, in respect of the disputed servient land, so the triangle did permit gigs to be stored there. And again, this is all relevant to what it is the respondent did on the subject land during the summer months. Finally, at paragraph 60 on page 121 is the discussion of the FTT, and then over the page at the top of 122, but the final sentence of paragraph 60 refers to the fact that the respondent can use that area as a car parking space during the summer months. Paragraph 61 and 65 make the point that in the winter months very little can take place. However, at 65 is the important exception to that, which is the final sentence, the final two sentences of 65, that motorists could interweave between the boats in the course of getting to the beach. So far as the documents and evidence are concerned, at page 226, 226 is the statement of the case before the FTT. Again, I can take you to it very briefly. And paragraph 7 of 226 sets out the alternative reasonable user that was put forward to the FTT. That's paragraph 7 on 226. Paragraphs 23 and 24 on 238 are paragraphs from Mr. Stenner's witness statement that was before the FTT. And if I could just ask you, 23 and 24, just to have a very quick scan of 23 and 24, which talks about, again, the other usage that the respondent made of the land. There are useful pictures at 354. There are various pictures from 351 of the bundle. 354 shows you the blue line, which is what the respondent painted. 355 shows you the white line. And as we know from the extracts of the FTT judgment I've taken, your lordships and your ladyship, too, the blue line succeeded the white line. That's 355. More pictures of the blue line at 356.
So what's the point of the blue and white line? I mean,
Was
that said to be, you're saying that's a use?
Well, it's there because it demarcates the servient land from the other land, but most importantly, what we know from the FTT judgment, the respondent during the summer months not only changed the colour of that land, more importantly, resurfaced this particular car park. And I'm going to come on, if I may, to explain why resurfacing is a reasonable user left to the servient owner.
Well, you've got 2 minutes in which to do that.
In which case, I'm very grateful. Please, can I take you to Batchelor and Marlowe, page 424. At 424 is the discussion in the Court of Appeal, and in the Court of Appeal, the discussion alights on what it is that the dominant owner could and could not do during the times when the cars were not parked there, and that feeds into the first of the limbs of ground 2, which is that the judge was wrong to exclude the summer months. You'll see that at paragraph 16 and 17 on 424. I'm then going to move to two authorities that explain that resurfacing car parking is a reasonable alternative user. The first is at 1028. This is the case of Verdi and Charner. And at paragraph 25, the judge makes the point that the ability of the domestic owner to alter the surface of a car parking area is reasonable user. The same point is made, that's 1033 for your references, the same point is made at 520. That's the case of De La Cunha at 520, and at 520, and if I can just ask you, just for your own internal records, just to, if you be so bold, make time to read paragraphs 14, 17 and 22 of this particular case, which again goes to the fact that being able to put utilities under or over land is also reasonable user. Moncrief makes the same point itself at 747, 747 FG 748. Lord Scott makes the point that the ability to run utilities under or over the land can also constitute reasonable user. If I now just finish my submissions as to where we are on the evidence, we know that during the winter months, the public walk through, we know that the respondent has changed the surface of the land. There's car park in the summer granting license to the rowing club. Where does that leave us? Well, if we go back to my skeleton argument at paragraph 43 on ground A, I submit that to exclude non-operative periods is to distort the test as it's been formulated in London and Blenheim, and there's no case law authority for it. On the second point of ground 2, I make the point that simply that the focus is on potential alternative user and not actual user. So the fact that there were no utilities run under the land is neither here nor there, because when we're looking at whether the serving owner is left with reasonable use of the land, the question is on potential alternative user, not actual user. And then finally on point C, I make the point there's no warrant in either London and Blenheim or Batchelor and Marlowe for the idea that we discount user which, because of the surrounding land, is of no practical benefit to the respondents. The point remains that because individuals could walk through the boats and sometimes did walk through the boats, that is sufficient for the reasonable user tests. My lords, my lady, I'm sorry for that barrage of submissions.
Well, you weren't left very much time by Mr. Holland, but the consequence is that your reply time, Mr. Holland, has now been used up. Yes, with that, Mr. Ward.
Still have 8 minutes.
Oh, really? Have I miscalculated? It's 15 minutes, 15 minutes. I think it's... Yeah, no, we're having a debate about whether I miscalculated, but I don't think I have. I think you have used up your replying time. Yes, Mr. Ward.
My lord, my lady, I'm conscious of the time myself, so I shall try and make sure that I finish at a suitable time with something sensible and consistent. What I propose to do, with your leave, is to make a general observation and then reply hopefully more comprehensively to my learned friend's case. What I do say is I express my gratitude for him taking us through the authorities. In many respects, they are the authorities to which I should like to speak, so hopefully I will be able to save some time. With that in mind, my lords, my lady, the main thrust of my submission really on ground 1 is that the principle that possession and control should represent the threshold for the Ouster Principle is too high a threshold. And I say it's infected with difficulty, which actually worsens the position that we find ourselves in with the authorities as they are. And it is also to overlook what I will say really does stand out of authorities which are not impugned in this appeal. Those authorities talk about the dilution of proprietary or ownership rights as being a trigger, and I will speak to these specifically in due course. Beneficial user, virtually a claim for possession, deprivation of enjoyment, joint occupation. None of those things by themselves necessarily amount to possession. So to accept the test contended for by the appellant would be not only to row back from Batchelor and Marlowe, not only to clarify reasonable user, but to ignore all of those other matters. Now, I accept that reasonable use as a test might benefit from some clarification. I accepted that in my written statement of case, and I don't distance myself from it now. But I do say that possession goes far too far.
And you mean legal possession, don't you, when you say possession?
Yes, my lady, I do, and that is exactly a point, because it does seem to me, again, in the authorities, there is reference to possession made, and I think on occasion that reference probably is more akin to occupation. And I say the introduction of, or the clarification of, this concept of not acting in a way that is inconsistent with proprietorship or ownership does deal with that. It does square that circle, because it can deal with possession as part of that, but it needn't.
Sorry, I didn't understand that. What are you saying?
What I'm saying, my lady, is that possession and control is insufficient to encapsulate.
Well, you said it was too high.
Yes, I say it's too high.
Right.
And I say if we add proprietorship or reference to inconsistency with ownership or beneficial ownership, then we deal with this tension.
So what exactly
So
will you say should be added?
What is the test, then, that you're advancing?
The test that I am advancing, I stand by the existing test.
Reasonable user.
Reasonable user, not so as to render ownership illusory, which I say is part of the test. I say that is a restatement of...
Sorry, so reasonable user that doesn't render ownership illusory. Is that the test?
Reasonable user should remain to the servient tenement, and the dominant tenement's user should not be such as to render ownership illusory.
Which paragraph of your written case do you set that test out in, just so we've got it for reference?
34.
Yes, is it paragraph 34?
Yes, indeed so.
That's the one we should concentrate on. Yes, thank you.
Sorry, forgive me, I can't remember the reference offhand.
Don't think that is.
My fallback proposition...
Sorry, I just want to confirm, paragraph 34 is the place.
I'm so sorry, my Lord, yes.
Paragraph 34 is
Yes,
where you formulate
indeed so.
the
Yes, it is.
writing. Yes. Yes, thank you.
My fallback proposition is, if there is to be this reference to possession and control, then we should also see reference to proprietorship. The test in those circumstances should be such that the user by the dominant tenement is not inconsistent with the proprietorship of the servient tenement.
Now, in that formulation, you have run together a reference to, if there is to be reference to possession and control, but I don't think Mr. Holland seeks to introduce control into his formulation. He just focuses on possession. So if there's reference just to possession, do you still need to refer to proprietorship?
Yes, my lord.
And what does proprietorship mean in that context?
Proprietorship in that context refers to the bundle of rights that an owner or a title holder has. It is entirely possible to be a proprietor without being in possession. You can be the proprietor of a reversionary interest, for example.
I'm not sure that if it just means the bundle of rights that an owner or title holder has, that that's going to be very helpful, is it? Because that's just the result of whatever legal test happens to be applied. So if they don't have rights to interfere with use by someone purporting to exercise an easement, then to that extent their bundle of rights has been diminished, and proprietorship doesn't really give us a criterion against which we can assess whether it is an easement or not.
Well, my lord, I accept that, and I accept the difficulty with the proposition, which is why I prefer the test as I formulate it. But what I say is there still needs, if we are to be faithful to the authorities which are not attacked as part of this appeal, there is this reference to the user not being inconsistent with ownership or proprietorship. And that distinction is made by the court in various cases. And indeed, we spent some time this morning discussing exactly what that distinction is and what distinction was had in mind in those circumstances.
Yes. I wonder if that might be a convenient moment at this point. Very good. Very well. We'll break there. We'll resume, please, at 2 o'clock.